Imagine your favorite app, the one you scroll through every single day, suddenly facing, well, an existential threat right here in the US. We're talking about an app that millions of us, maybe even you listening right now, rely on for everything from, entertainment to news, connecting with friends. That's exactly what's been happening with TikTok. And it's a situation that has left, 170 million US users and creators just wondering what comes next.
It really is an unprecedented situation. It shines a light on this intricate dance between global tech, national security, and, well, our individual rights in this digital age.
It absolutely does. So today we're taking a deep dive into the legal side, the national security implications of a recent, really landmark Supreme Court decision. Our mission: to help you understand the complex interplay between free speech, corporate control, international relations, specifically as they apply to this law, the Protecting Americans from Foreign Adversary-Controlled Applications Act. The TikTok law, basically.
Right. We're going to unpack the Supreme Court's per curiam opinion. And just quickly, per curiam means it's an opinion by the court as a whole, not tied to one specific justice writing it. We'll also dig into the, frankly, fascinating and sometimes diverging insights from the justices who wrote concurring opinions. We want to get to the heart of why this decision was made and, crucially, what it means for you, those 170 million US TikTok users, and really for the broader future of digital platforms, how we all interact online.
And to do that, we're going straight to the source today. The Supreme Court's own words. Their official opinion is our main guide. It gives us a direct, authoritative look at their reasoning. It's kind of a unique window into how the highest court in the land is grappling with these incredibly complex, modern challenges, where tech, law, and global politics all collide. Okay, so TikTok's facing this huge challenge, but to really get the Supreme Court's reasoning, we first need to understand the sheer scale, the unique nature of this platform, and, why exactly it became such a focus for national security concerns. What is TikTok fundamentally, and just how big are we talking?
Exactly. Context is key here. TikTok isn't just, another social media app. It's a global phenomenon. Think about it. Since launching back in 2017, it's pulled in over 170 million users just here in the United States. Worldwide, that number is, it skyrockets to over 1 billion users. And get this, in just 2023 alone, US TikTok users uploaded something like 5.5 billion videos. Those videos were collectively viewed more than 13 trillion times across the globe. It's not just big, it's this colossal hub for making stuff, watching stuff. It's woven itself into daily life for so many people.
And what really sets it apart, maybe even more than the volume, is that personalized experience, right? You open the app, bam, you're on the For You page. That's not just a simple feed of who you follow, is it? It feels way more sophisticated, almost like it knows what you want to see before you do.
No, it's definitely not simple. That For You page runs on a proprietary algorithm. It's constantly learning about your interests, your preferences, based on, everything you do on the app, every video you linger on, every account you follow, comments you leave, shares. All of it feeds this recommendation system. It tailors your feed in real time. Don't just think of it as recommendations. Think of it more like a digital mirror, constantly watching your behavior, your preferences, maybe even your mood. Every tiny interaction is a data point. It designs an experience specifically for you. It's highly intelligent, always optimizing to keep you scrolling.
And that engagement, wow, it could be incredibly powerful. I think we've all probably gotten lost down that For You page rabbit hole at some point. But what I also gather is that TikTok isn't just passively showing content, it actively moderates it, and it can even promote, or I guess demote, certain information. How does that control piece factor into the government's concerns, especially when you layer in the ownership structure?
Right. That control over content promotion and visibility is a really critical aspect, especially when you connect it to ownership.
Precisely. So TikTok Inc., the company operating here in the US, it's technically an American company, headquartered out in California. However, its ultimate parent company is ByteDance Ltd. And ByteDance is a privately held company with significant operations based in China. Okay, and that's where the red flags really start topping up for the government, isn't it? Because it's not just the org chart, it's where the core tech comes from. I mean, lots of global companies have teams everywhere. What's specific about Chinese law and ByteDance that makes this different?
Exactly. TikTok's proprietary algorithm, the very engine driving that For You page, it's developed and maintained in China by ByteDance. Key parts of the source code, the instructions that run the whole platform, they also originate there. Now, here's the kicker, the really crucial detail. ByteDance Ltd, being based there, is subject to Chinese laws, and these laws fundamentally change the game. They require companies like ByteDance to assist or cooperate with the Chinese government's intelligence work. They also ensure the government has the power to access and control private data held by the company. This isn't some vague possibility, it's a legal mandate under Chinese law. It creates a direct potential pipeline for data access or even control by the Chinese state.
Wow. Okay, so it's not just where the HQ is, it's the legal duties the parent company has to a foreign government, one designated as an adversary. That immediately sounds like a national security alarm bell. Can you walk us through the timeline? How did the U.S. government try to deal with this before we got to this specific act in the Supreme Court?
Sure. The concerns aren't new. They started getting louder a few years back. In August 2020, President Trump issued an executive order. It explicitly said mobile apps developed and owned by Chinese companies were a national security threat to the U.S. economy, foreign policy, the works. He specifically named TikTok, citing its huge data collection and its potential vulnerability to Chinese government influence. He used emergency economic powers to try and prohibit certain transactions with ByteDance. But federal courts pretty quickly enjoined those prohibitions, basically. They put a legal stop sign up, finding they might have overstepped the executive branch's authority under that specific emergency power.
So that first attempt got blocked by the courts. What was Plan B? Did they shift strategy?
Yeah, just days after that first order, President Trump issued a second one. This time, it was much more direct. It ordered ByteDance to divest, to sell off all its interests and rights in its U.S. TikTok operations and all the data it had gathered from U.S. users. ByteDance and TikTok challenged that order in the D.C. Circuit Court. But then, in February 2021, the D.C. Circuit put the case on hold, essentially paused it. This was a bit of a strategic pause, really. It let the incoming Biden administration review the whole situation and try to negotiate what they called a non-divestiture remedy, some kind of solution, maybe, that wouldn't require a full sale but would still fix the national security problems.
Okay, so it sounds like they tried to find some middle ground, maybe a compromise. Did those talks go anywhere?
Well, they tried. Throughout 2021 and into 2022, ByteDance was negotiating with executive branch officials, trying to hammer out a national security agreement. But ultimately, U.S. officials decided that ByteDance's proposed deal just didn't adequately mitigate the risks posed to U.S. national security interests. The talks basically stalled. No agreement was ever finalized, and that original divestiture order from 2020 just kind of stayed there, hanging in legal limbo.
Which brings us finally to the actual law we're dissecting today. The Protecting Americans from Foreign Adversary-Controlled Applications Act, PIFACA for short. So what was Congress trying to do this time? How did its core prohibition differ from those earlier attempts that, well, didn't quite stick?
Congress really went for a much more direct, forceful approach with PIFACA. The act makes it flat-out unlawful for any entity, think app stores, internet hosting services, to provide services to distribute, maintain, or update what it defines as a foreign adversary-controlled application here in the United States. If you violate this, you face civil enforcement actions, big monetary penalties. It's essentially saying if you're controlled by a designated foreign adversary, you cannot operate here unless you change hands. It's a fundamental shift. Instead of just trying to manage data flows or negotiate agreements, it mandates a change in ownership structure, a measure designed arguably to be cleaner and withstand those earlier legal challenges.
And how does an app actually get that label? Foreign adversary-controlled application. Is it just TikTok automatically, or is there a broader process?
Good question. The Act sets up two ways this can happen. First, and this is directly relevant to our discussion, the Act expressly designates any application operated directly or indirectly by ByteDance Ltd. Or TikTok or any of their subsidiaries or successors. So yes, TikTok is specifically named. It's caught by that first mechanism, no extra steps needed. Second, the Act also creates a broader, more general framework for future designations. This can apply to any app that meets a few criteria. It has to be operated by a covered company, which means having over 1 million monthly active U.S. users and enabling user-generated content, and that company has to be controlled by a foreign adversary country like China, Russia, Iran, North Korea. And the president has to determine it poses a significant threat to U.S. national security following a public notice process.
Okay, so it's both targeted at TikTok right now, and it sets up a system for potentially designating other apps down the road. Are there any apps specifically excluded from that general framework, like any safe harbors?
Yes, there is a specific carve-out in that general framework part. Applications whose primary purpose is letting users post things like product reviews, business reviews, or travel info and reviews, those are excluded from the covered company definition. So think platforms like Yelp or TripAdvisor. They wouldn't typically be caught by the general provisions based on that specific wording about their primary purpose.
This sounds pretty final, like a hard deadline. When did this act actually kick in for TikTok, and what was the immediate consequence? What happens now?
The Act's prohibitions for any designated application took effect 270 days after it was enacted. Since ByteDance and TikTok were expressly named in the Act itself, those prohibitions kicked in for them on January 19, 2025. What that means is TikTok can no longer legally operate in the U.S. unless something called a qualified divestiture occurs. The clock started ticking the moment the Act became law, and, well, that deadline has passed.
Qualified divestiture. That sounds like the key escape hatch.
Yeah.
But it also sounds like more than just, selling the company name. What exactly does that involve? What makes a divestiture qualified?
You're right, it's much more rigorous than a simple sale. A qualified divestiture is defined as a sale or transfer that the president determines conclusively will result in the application no longer being controlled by a foreign adversary. But it goes much further than just the ownership papers. The president also has to determine that the divestiture, quote, precludes the establishment or maintenance of any operational relationship between the U.S. operations of the app and any formerly affiliated entities controlled by a foreign adversary. This explicitly includes any cooperation with respect to the operation of a content recommendation algorithm or an agreement with respect to data sharing. So essentially, it means a complete and total severing of all ties, ownership, operational control, the algorithm itself, all data flows, not just selling off the U.S. branch. The Act does allow for a potential one-time 90-day extension to that deadline, but only if the president certifies there's significant progress being made toward achieving such a qualified divestiture.
Okay, so the clock is run out, and the core issue is that foreign control and data access. But obviously, this isn't just a national security regulation. It immediately brings up huge First Amendment issues, right?
Yeah.
Especially with 170 million Americans using the platform. How did the challengers, TikTok, and the users frame their First Amendment case?
Precisely. This is where the legal rubber really met the road. The parties challenging the act were TikTok Inc., ByteDance Ltd., and also a group of US-based TikTok users and content creators. Their central argument was pretty straightforward. They asserted that the Act's prohibitions, its specific naming of TikTok, and that forced divestiture requirement, all of it violates their First Amendment rights, particularly freedom of speech. They essentially framed it as an outright ban on a hugely popular platform for expression.
And before it landed at the Supreme Court, it went through the D.C. Circuit Court first. What was the ruling there? And what kind of legal tests or scrutiny did they use?
The D.C. Circuit denied their petitions. They found no First Amendment violation. That court applied what's called heightened scrutiny. They actually went so far as to assume the toughest standard, strict scrutiny, applied, and still found that the government's national security reasons were compelling and the act was narrowly tailored enough to achieve those goals. Just as a quick reminder for everyone, strict scrutiny is the highest bar in constitutional law. The government has to prove the law is basically the only way possible to achieve an absolutely critical or compelling government interest, like, national survival, and that the law doesn't accidentally restrict more speech than necessary. It's incredibly hard for a law to survive strict scrutiny. It's also worth mentioning, though, that Chief Judge Srinivasan wrote separately, concurring, saying he thought intermediate scrutiny, a slightly lower but still demanding standard, was actually the more appropriate test here.
Okay, let's unpack this for the Supreme Court's deliberation then. This First Amendment scrutiny question gets really nuanced, doesn't it? The core issue the Supreme Court had to wrestle with was, does this act, which targets ownership and control, even trigger First Amendment review in the first place? It seems tricky because it's not directly banning what you say, but who owns the bullhorn you're using.
It's a very complex question, exactly, because the Act primarily regulates ByteDance and TikTok Inc.'s corporate structure, demanding divestiture rather than directly telling users what they can or can't post. The court seemed hesitant, actually, to say the Act directly regulates expressive activity or conduct. They pointed out that the petitioners couldn't really identify any previous Supreme Court case where regulating corporate control like this was treated the same as directly regulating speech or conduct with an expressive element. That distinction is critical. They're careful not to rule directly on the speech, but on the ownership structure of the platform carrying the speech. That's relatively new territory for First Amendment law.
So they were cautious about setting a broad new precedent, saying that regulating a company's structure automatically equals regulating speech. But the challengers still had a powerful point that the act does impact speech rights, even if indirectly. What was their strongest angle there?
Absolutely. Their strongest argument was framed around the idea that the act imposes a disproportionate burden on their First Amendment activities. They argued that because, practically speaking, divesting TikTok within the Act's tight timeframe was commercially infeasible, the Act effectively is a ban on TikTok in the U.S. And that ban, they contended, heavily burdens a whole range of First Amendment activities. TikTok's own content moderation, which is seen as editorial discretion, the user's content generation, everyone's access to what they see as a distinct and important medium for expression, the right to associate expressively with other users or with TikTok as their preferred platform, and of course, the fundamental right to receive information and ideas.
And the court did acknowledge those points, right? They didn't just dismiss the impact on users, even if they were careful about the legal test.
That's right. The court definitely recognized a number of those asserted First Amendment interests. They cited their own precedents on things like editorial discretion, laws that basically shut down an entire medium of expression, the right of expressive association, and that core right to receive information. The court explicitly said, and this is a direct quote, "An effective ban on a social media platform with 170 million U.S. users certainly burdens those users' expressive activity in a non-trivial way." That's a crucial admission. They see the significant impact on your ability as a user to express yourself. However, it's also important they clarified something else. Generally, foreign organizations operating abroad, like ByteDance Ltd. itself, don't possess First Amendment rights within the U.S. That was relevant to ByteDance's specific claims.
Okay, so they acknowledged the real burden on speech for U.S. users, but they took this very specific path regarding how to apply First Amendment scrutiny. This seems really key to understanding the final decision. What did they ultimately decide about the review framework?
Indeed, this is where the court kind of navigated new waters. They noted that a law targeting a foreign adversary's control over a communications platform is, in many ways, different from the usual kinds of regulations of non-expressive activity that they've previously subjected to First Amendment scrutiny. These differences, the law's focus on a foreign government, the fact Congress explicitly designated that government an adversary, the sort of complex chain of cause and effect between regulating ownership and the burden on user speech, all these factors made applying existing frameworks tricky. And here's the really critical move. The Supreme Court assumed, without deciding, that the challenged parts of the Act are subject to First Amendment scrutiny. They deliberately didn't establish a new, definitive legal test for how regulations of non-expressive activity, like corporate ownership, that disproportionately burden expressive activity, like user speech, should be reviewed. This really signals how unique and evolving they saw this case, especially in the digital age. They proceeded cautiously, avoiding setting a potentially problematic precedent for all future tech regulation cases.
That makes a lot of sense. They know they're dealing with fast-moving tech and global politics. Okay, so once they assumed First Amendment scrutiny applies, they had to decide which level of scrutiny. This brings us to that classic legal distinction: content-based versus content-neutral laws. Can you break those down quickly for us non-lawyers?
Absolutely. It's fundamental to First Amendment law. The core idea is that individuals, not the government, should decide what ideas are worth expressing or hearing. So government actions that restrict speech because of its message targeting what's being said are called content-based laws. These are viewed very suspiciously, they're presumptively unconstitutional, and face strict scrutiny, that super high bar we talked about. The government has to prove the law is narrowly tailored to serve an absolutely compelling state interest. It almost never passes.
Right, strict scrutiny, the toughest test. So what about content-neutral laws? What's the standard there?
Content-neutral laws, on the other hand, are laws that are unrelated to suppressing the speech itself. They usually regulate the time, place, or manner of speech, how or where it happens, not what is said. Or, as potentially relevant here, they regulate conduct for reasons unrelated to the speech. These laws face a lower, though still significant, hurdle called intermediate scrutiny. Under this test, the law is usually upheld if it advances important government interests that are unrelated to suppressing free speech, and if it doesn't burden substantially more speech than is necessary to achieve those interests. It gives the government a bit more leeway than strict scrutiny. This distinction is often the whole ballgame in First Amendment cases.
So the big question: how did the court classify this act, the TikTok law? Content-based, triggering strict scrutiny, or content-neutral, getting intermediate scrutiny?
The court found the Act's provisions, as applied to TikTok, to be facially content-neutral and justified by a content-neutral rationale. This is really key. They determined the law isn't fundamentally about what people are saying on TikTok, but about who controls the platform. The Act singles out TikTok because of a foreign adversary's control, and it makes divestiture the condition for continuing to operate. It doesn't target specific messages or viewpoints. And importantly, TikTok and ByteDance can't get around the law just by changing the content on the platform. The court was clear. It's about the foreign adversary's control, not the content itself.
But what about that exception we mentioned earlier, the one for review platforms like Yelp? The petitioners argued that China made the act content-based because it seemed to favor certain kinds of speech reviews over others. How did the court handle that point?
That's a sharp question. The court basically said they didn't need to decide whether that specific exclusion for review platforms was content based on its own. The crucial point for this case was that the exclusion only applies to the general framework for designating apps in the future. It does not apply to the specific designation of TikTok, which happened directly in the text of the act itself. Since TikTok was designated by name, that review platform exclusion simply wasn't relevant to TikTok's specific challenge to the law as it applied to them. It didn't affect their situation.
Okay, got it. And the government's main justification preventing data collection by China. Why did the court see that reason as content neutral?
The government's primary reason, preventing China from potentially accessing the sensitive data of 170 million U.S. TikTok users via its control over ByteDance, was seen by the court as decidedly content agnostic. In other words, that justification doesn't care about the actual content of the TikTok videos or messages. It doesn't reflect any disagreement with the ideas being expressed. It's purely focused on the data being collected and the risks of foreign access to that data. Because this data security concern reflects a purpose unrelated to the content of expression, the court deemed it a content-neutral justification.
What about the fact that the law did single out TikTok by name? Usually, targeting one specific speaker raises serious First Amendment alarms and might trigger strict scrutiny. How did they justify treating TikTok differently?
That's a very valid point, and the court addressed it directly. They acknowledged that laws restricting speech based on the speaker's identity often do raise serious First Amendment concerns, because sometimes that's just a sneaky way to target the speaker's message. However, they clarified that strict scrutiny is unwarranted when the differential treatment is justified by some special characteristic of the particular speaker being regulated. The court found that TikTok does have such special characteristics, specifically the combination of its massive U.S. user base, 170 million people, the fact that it's controlled by a company subject to the laws of a designated foreign adversary, China, and that adversary's ability to potentially leverage that control to collect vast amounts of sensitive personal data. These factors, they said, justified the differential treatment. They concluded this wasn't just a subtle means of exercising a content preference. It's important to see this ruling as quite narrow, tied specifically to TikTok's unique circumstances. It's not a green light to target any platform. Any future law would need its own justification.
So the final verdict on the level of scrutiny was pretty clear then. Intermediate scrutiny it is, not strict.
Yes. Considering all these factors, the Supreme Court concluded no more than intermediate scrutiny is in order. That became the standard they used to evaluate whether the act passed constitutional muster. This made the government's job of defending the law significantly easier than if strict scrutiny had been required.
Okay, which brings us squarely to the government's main justification under that intermediate scrutiny standard.
Yeah.
National security, focusing specifically on data collection and maybe the algorithm too. How did the court weigh this? Was preventing data collection by China seen as an important enough interest?
Absolutely. Under intermediate scrutiny, remember, the act needs to further an important government interest unrelated to the suppression of free expression and be reasonably tailored. The court had little trouble concluding that preventing China from leveraging its control over ByteDance to potentially capture the personal data of 170 million U.S. TikTok users qualifies as an important government interest. This was the central pillar of the government's case, and the court fully accepted it.
And let's talk about that data again. What exactly are we talking about here? Beyond just watching funny videos, what kind of sensitive private information did the court focus on that raised these alarms?
It's truly extensive, according to the record the court reviewed. The platform collects vast amounts of sensitive personal information. We're talking specifics like your age, your phone number, your precise physical location, your IP address, which links to your network, the specific device you're using, your phone contacts list, connections to other social networks, the actual content of private messages you send within the app, and detailed records of the videos you watch. It also gathers behavioral data, including, get this, things like your keystroke patterns and rhythms, basically how you type. And it can potentially access data from your device, contacts, and calendars if you grant permission. For instance, the records showed that if you allow TikTok access to your phone contacts to find friends, it can access any data stored in the user's contact list. Names, phone numbers, emails, photos, job titles, even notes attached to contacts. So think about that. It's almost every digital footprint you leave on the app, plus potentially sensitive data about your friends and contacts who aren't even on TikTok if you gave it that contact's permission. It's not just what you post, but this huge web of data connected to you.
Wow, that is a staggering amount of personal detail. So connect the dots for us. So what? Why does the government see potential Chinese access to that specific data as a direct national security threat?
The government's core concern, which the court acknowledged, is that China could potentially exploit this data trove for various intelligence purposes. Specifically, they raised concerns about using it to track locations of federal employees and contractors, build dossiers of personal information for blackmail, and conduct corporate espionage. It's not just about mass surveillance in the abstract. It's about gathering intelligence, potentially identifying vulnerabilities, and targeting specific individuals or organizations within the U.S. And this concern is massively amplified, as we discussed, by those Chinese national security laws. Those laws essentially provide a legal mechanism for the Chinese government to compel companies like ByteDance to hand over data for intelligence work, turning that vast data collection from a commercial asset into a potential state intelligence tool.
The petitioners, TikTok and ByteDance, they pushed back on this. Right? They argued it was unlikely China would actually compel them to turn over data, maybe suggesting China had easier ways to get info. How did the court handle that kind of "it probably won't happen" argument, especially when Congress is making predictions about future risks?
The court showed significant deference to Congress's predictive judgments in the realm of national security. They essentially said, look, making good policy often requires lawmakers to anticipate future threats and make informed guesses, even if they don't have perfect, concrete proof of what will happen. They quoted precedent saying, sound policymaking often requires legislators to forecast future events, for which complete empirical support may be unavailable. The court emphasized that the record did reflect China's extensive and years-long efforts to accumulate structured data sets on U.S. persons for intelligence purposes. In areas like national security and foreign policy, where information is often classified or hard to get, the court gives substantial respect to the informed judgment of the political branches, Congress and the president. They weren't inclined to second-guess Congress's assessment of the risk here.
And what about the other counter-argument that the law was under-inclusive? The idea that if data collection is the real problem, why only target TikTok and apps controlled by specific adversaries? Why not regulate data brokers or other apps too? How did the court respond to that?
The court pretty quickly dismissed the under-inclusiveness argument. They stated flatly that the First Amendment imposes no freestanding under-inclusiveness limitation. Basically, the government doesn't have to solve an entire problem all at once. They can choose to address one aspect of a problem first. The court reiterated that TikTok was singled out for legitimate reasons: its massive scale, 170 million users, combined with its control by a company subject to a foreign adversary's laws. They found Congress was justified in tackling this specific national security concern related to TikTok, distinguishing it from situations where a law might unfairly target a speaker without a good reason. Essentially, the government can address the biggest, most pressing part of a problem first, and TikTok, in their view, fit that description.
Okay, so the government's interest in stopping data collection was deemed important, and the court deferred to Congress's judgment on the risk. Now, the second part of intermediate scrutiny was the act sufficiently tailored. Did the solution fit the problem without being overly broad? Remember, it doesn't have to be the least restrictive option, just reasonably fitted.
That's exactly right. Intermediate scrutiny doesn't demand the least speech-restrictive means. The regulation just needs to promote a substantial government interest effectively, and not burden substantially more speech than is necessary to achieve it. The court found that the Act's approach prohibiting operation unless there's a qualified divestiture clearly serves the government's data collection interest in a direct and effective way. They reasoned that without that divestiture, TikTok's continued operation inherently carries the data collection risks Congress identified. The divestiture requirement, by severing foreign adversary control and operational ties, including data sharing, directly addresses those risks before the platform can operate legally again.
So the court really leaned into this idea that it's not an outright ban, but a conditional one. It's sell it properly or you're shut down.
Exactly. The court repeatedly emphasized this framing. It's a conditional ban. It prevents TikTok from operating unless and until a qualified divestiture happens, completely severing China's control and operational links. They saw this not as a blunt shutdown of speech, but as a demand for a structural change, a change in ownership and operational independence that directly addresses the identified national security threat, the data access. The court concluded this approach was not substantially broader than necessary to achieve that crucial security objective. It's a dramatic step, yes, but they felt it was tailored to the specific problem of foreign adversary control over this massive data collecting platform.
Now, the petitioners naturally suggested alternatives. They said, hey, what about just requiring disclosures or stricter rules on data sharing? Or let's revisit that national security agreement we tried to negotiate. How did the court react to those proposed alternatives? Did the existence of alternatives mean the act wasn't tailored enough?
The court considered those alternatives, but ultimately found they didn't change the outcome of the tailoring analysis. They reiterated a key principle. The government gets considerable latitude in choosing how to address legitimate content-neutral concerns. A regulation isn't automatically invalid just because a court thinks there might have been a less speech-restrictive way to achieve the goal. As long as the path Congress did choose is most substantially broader than necessary, it can stand. The court stated that the government's chosen policy here, the conditional ban via divestiture, was grounded on reasonable factual findings supported by evidence that is substantial for a legislative determination. Basically, Congress did its homework, had reasons for choosing this path over others, like the failed negotiations, and the court wasn't going to substitute its own judgment on the best policy solution.
Can you give us a concrete example of why some of those alternatives might have been seen as insufficient? Like, why wasn't just warning users considered enough, or why wasn't simply banning data export seen as workable?
Certainly. And Justice Gorsuch's concurring opinion actually elaborated on some of these points quite effectively, illustrating the broader court's likely thinking. For instance, just putting up warnings, more speech about data risks, wouldn't protect the data of non-users. Think about that contact list data we mentioned. People not even on TikTok could have their info scraped, and warnings wouldn't help them. As for forbidding data export with penalties, the concern there, reflected in the record, was enforceability. Could it be circumvented through sophisticated means like malicious code, backdoor vulnerabilities, surreptitious surveillance? Given the sheer size and complexity of TikTok's software, detecting such hidden data siphoning could be virtually impossible. Plus, would standard penalties even deter agents of a foreign adversary state? Maybe not. And then there's the flip side. Setting up a really intrusive government monitoring regime to ensure data wasn't flowing could create its own set of privacy problems and government overreach concerns. These practical difficulties made the divestiture route seem more direct and effective to Congress and ultimately to the court.
Okay, this has been a really insightful breakdown of the main per curiam opinion. But, as you mentioned, not all the justices signed on to every single part. There were important concurring opinions offering different shades of reasoning. Let's start with another potential government interest, this idea of preventing covert manipulation through the algorithm. Did the main opinion rely on that?
That's a really interesting point. So, besides the primary data collection concern, the government also argued it had an interest in preventing a foreign adversary from potentially controlling TikTok's recommendation algorithm to secretly manipulate content. Push propaganda, suppress certain views undetected. The petitioners jumped on this, arguing that justification was content-based, because it's about the content being manipulated, and that it tainted the whole rationale, demanding strict scrutiny.
So how did the majority opinion handle this covert manipulation argument? Did they agree it was content-based? Did they rely on it?
They actually sidestepped it. The court explicitly did not decide whether this content manipulation rationale was content-neutral or content-based. They also didn't rule on the tricky question of what standard applies in these mixed justification cases, where the government offers both content-neutral reasons, data, and potentially content-based ones, manipulation. Instead, the court took a different route. They concluded that the legislative record adequately supported the idea that Congress would have passed this act based solely on the data collection justification alone, regardless of the manipulation concern. They essentially said, even if we set aside the manipulation argument entirely, the data collection threat is independently strong enough to justify this law under intermediate scrutiny.
That's a powerful finding that the data issue alone was sufficient. What specific evidence did they point to in the record to support that conclusion?
They leaned heavily on the House report accompanying the act. The court noted that this report focused overwhelmingly on the government's concerns about data collection. It highlighted, for example, the sheer breadth of TikTok's data gathering, the difficulty in assessing precisely which categories of data it collects, the tight interlinkages perceived between TikTok, ByteDance, and the Chinese government, and China's legal ability to coerce companies into providing data. The court saw this legislative history, combined with the really striking bipartisan support the act received, passing 352 to 65 in the House and 79 to 18 in the Senate, as strong evidence that the data collection concern was the primary overriding driver for Congress.
And the divestiture requirement itself, which includes severing ties related to the algorithm, how did the court connect that back to the data collection justification if the algorithm seems more about content?
That's a key connection they made. The government argued, and the court seemed to accept, that the algorithm and data collection are deeply intertwined. How? Because ByteDance uses U.S. user data to train TikTok's recommendation algorithm, which is developed and maintained back in China. Apparently, ByteDance had previously refused to agree to stop collecting U.S. user data or sending it to China for this training purpose during those earlier negotiations. Furthermore, the court acknowledged the significant practical difficulties in effectively monitoring data sharing related to the algorithm between ByteDance in China and TikTok Inc. in the U.S. Given these factors, the court found the data collection justification was sufficient to support all the challenged provisions, including the requirement to divest the algorithm, because the algorithm's operation was so closely linked to the problematic cross-border flow and use of U.S. user data.
Fascinating. Okay, let's shift to Justice Sotomayor's concurrence. She agreed with the final outcome, but took issue with one specific part of the majority's reasoning, right? Particularly on whether the First Amendment was clearly implicated from the start.
Yes, exactly. Justice Sotomayor joined almost all of the per curiam opinion, except for the part where the majority assumed without deciding that the act implicated the First Amendment. Her view was much more definitive. She wrote separately to state that she saw no reason to assume without deciding that the act implicates the First Amendment because our precedent leaves no doubt that it does. She thought it was obvious.
And what was her reasoning for that strong conviction? Why did she think it was such a clear-cut First Amendment case right off the bat?
She laid out several points based on existing precedent. First, she argued that TikTok itself engages in expressive activity when it compiles and curates content on its platform. It's acting like an editor, not just a neutral pipe. Second, she stated the act plainly imposes a disproportionate burden on that expressive activity because it outright bars TikTok's speech distribution in the U.S. unless it undergoes this divestiture. She also pointed out the act restricts TikTok's ability to collaborate with certain entities on its content recommendation algorithm even after divestiture. And finally, she highlighted that the act clearly implicates the content creator's First Amendment right to associate with their chosen publisher, TikTok, for the purpose of getting their message out. For her, these factors combined made it crystal clear that First Amendment scrutiny was required, not just assumed.
So a much more direct First Amendment analysis from her perspective. Then we have Justice Gorsuch, who also concurred in the judgment, but seemed to bring a number of reservations and practical observations to the table. Connecting this to the bigger picture, what was his overall perspective? He seemed aware of the rush, for one thing.
He definitely was. Justice Gorsuch started by acknowledging the incredibly tight timeline the court operated under, referring to the mere fortnight, just 2 weeks, between the final briefs and issuing the opinion on such a complex, high-stakes case. This led him to explicitly frame his thoughts as admittedly tentative observations, signaling a degree of caution due to the compressed schedule.
And he had a specific take on that covert manipulation justification that the main opinion mostly sidestepped. He seemed quite concerned about that from a First Amendment standpoint.
Very much so. He explicitly stated he was pleased that the court refrains from endorsing the government's asserted interest in preventing the covert manipulation of content as a justification. His reasoning was classic First Amendment thinking. One man's covert content manipulation is another's editorial discretion. He strongly emphasized the First Amendment's broad protection for speech and the media, even extending to foreign adversaries, suggesting that the fitting remedy for evil counsels is good ones, meaning the answer to bad speech is more good speech, not government censorship. He also voiced a broader concern about what he saw as increasing government efforts to censor disfavored speech online.
He also seemed to strongly agree with the court not relying on classified evidence, right? What was his concern there?
Yes. He expressed strong approval that the court declined to consider classified evidence that the government had submitted, but kept hidden from TikTok, ByteDance, and their lawyers. He flagged the obvious constitutional concerns this raised regarding fundamental fairness and due process. He underscored the basic principle that evidence used to prove a case against someone should generally be disclosed so they have a chance to challenge it. You can't effectively fight what you're not allowed to see. That was his core point on procedural fairness.
Interesting. And yet, despite concurring in the end, he also explicitly stated he had serious reservations about whether the law was truly content neutral. If he doubted the neutrality and the scrutiny level, why did he ultimately agree with upholding the act?
He did indeed express those serious reservations about content neutrality and whether intermediate scrutiny was truly appropriate. He even voiced a broader skepticism about how the whole tiers of scrutiny framework in constitutional law can sometimes obscure than to clarify the ultimate constitutional questions. He prefers focusing on the core principles. However, despite these legal framework reservations, he was ultimately persuaded by the strength of the government's core national security argument regarding data collection.
So what tipped the balance for him, despite those concerns about the legal tests?
He stated that regardless of the precise legal test applied, he was persuaded that the law before us seeks to serve a compelling interest. Preventing a foreign country, designated by Congress and the President as an adversary of our nation, from harvesting vast troves of personal information about tens of millions of Americans. He pointed specifically to the sheer volume and sensitivity of the data TikTok collects, including, importantly, data scraped from non-users via contact lists, and the reality of China's national security laws allowing it to compel cooperation. And crucially, he also found the law appropriately tailored, specifically because of the history here, the years of negotiations where alternative solutions were attempted but ultimately failed to satisfy the government's security concerns. That history of failed alternatives seemed key to his tailoring conclusion.
Right. He really hammered home why those alternatives seemed inadequate. Can you recap his specific points there? Why wasn't warning users or banning data export enough in his view?
Yes, he laid it out quite clearly. He argued that more speech, like user warnings, simply wouldn't protect the data of non-users whose info gets pulled in via contact lists. Their privacy remains vulnerable. Regarding banning data export with penalties, he echoed the concerns about enforceability. He noted the record suggested PRC agents wouldn't likely be deterred by U.S. penalties. More importantly, he highlighted the technical challenge. The sheer size and complexity of TikTok's software could make it practically impossible for U.S. authorities to detect violations hidden within malicious code, backdoor vulnerabilities, and surreptitious surveillance. How do you find a secret data leak in billions of lines of code controlled from abroad? He also raised that concern that a rigorous U.S. monitoring regime might itself lead to intrusive government surveillance of Americans' data. For him, these practical realities made the more drastic divestiture remedy seem necessary and tailored, given the failure of other approaches.
So his bottom line, while recognizing how dramatic the law is, was that the threat was real and the government's response, in this context, was constitutional.
Exactly. He concluded that while the law's remedy is indeed dramatic, the underlying problem appears real, and the response to it not unconstitutional. And he drew that sharp distinction at the end. Speaking with and in favor of a foreign adversary is one thing. Allowing a foreign adversary to spy on Americans is another. That really encapsulates the core tension the court grappled with, balancing vital speech freedoms against credible national security risks in the context of foreign-controlled technology and data.
What an incredibly complex ruling with huge implications for, well, potentially all of us who use digital platforms. So just to recap our deep dive here, the Supreme Court upheld the Protecting Americans from Foreign Adversary Controlled Applications Act. That means the conditional ban on TikTok in the U.S. stands unless it goes through a qualified divestiture that satisfies the president. The decision rested primarily on national security concerns about potential Chinese access to vast amounts of U.S. user data, and the court reviewed the law under intermediate First Amendment scrutiny, finding it sufficiently tailored given those concerns and the history of failed negotiations.
Right. And this ruling really throws into sharp relief that ongoing tension between national security needs and First Amendment rights, especially in our digital age with these powerful, globally interconnected platforms controlled from overseas. It definitely underscores the government's significant and, in the court's view, important interest in protecting citizen data from potential exploitation by foreign adversaries, particularly when those adversaries have laws compelling corporate cooperation.
Ultimately, this whole case, this decision, it really speaks volumes about the immense complexity of trying to regulate new technologies that don't respect borders and the constant challenge of balancing our fundamental rights like free expression with these evolving, sometimes invincible national security threats.
And it leaves us with a really important question to ponder, doesn't it? Considering how much weight the court gave to Congress's predictive judgments about future risks, and acknowledging how incredibly difficult it is to truly monitor or control global data flows, what does this ruling signal for the future? What might it mean for other international digital platforms operating here in the US, especially as global tensions shift and technology keeps evolving? Could this decision reshape the very architecture of the internet, maybe leading towards a more fragmented, nationally bordered digital world? It's definitely something to keep thinking about long after this deep dive ends.